Hello everyone, welcome back to another episode of our channel Law Point, and this is me Preeti Elizabeth Jensen here. If you happen to commit an offense knowingly or unknowingly and got arrested by the police for the same, there is a measure incorporated in our law to help you in getting released from the jail immediately. This feature is called bail and is topic of our today's discussion by Supreme Court of India's advocate on record, Mrs. Praseena Elizabeth Joseph.
Bail is the conditional release of a person accused of a crime against an amount pledged for securing the appearance of this accused during the time when the trial is proceeding in the court. When a person is arrested, he can get bail in two ways. They are, first of all, he can get bail through his own bond. This is a particular amount fixed by the police or by the court for the release of this accused person to be executed by the accused person himself. Secondly, he can get bail through surety bonds. That means third parties who are residents in India can guarantee the appearance of this accused person at the time of trial, and they need to deposit a sum of money as directed by the police or by the court as a security for securing the appearance of the accused person. There are different types of bail. One is bail in bailable offences. Secondly, bail in non-bailable offences. Thirdly, anticipatory bail. Fourthly, default bail. Fifthly, bail after conviction. In this episode, we will be talking only about bail in bailable offences as well as bail in non-bailable offences. Now, let's see how bail is granted in bailable offences. What are bailable offences? They are simple injury, bribery, public nuisance, threat of injury to public servants, being part of unlawful assembly, etc. According to section 436 of the Code of Criminal Procedure, if a person is accused of a bailable offence, then the accused is entitled to bail as a matter of right. He can obtain bail from magistrate court or from the police station. In bailable offences, there is not a chance that the bail being denied to the accused person, because there is a statutory duty imposed upon the police or the court to release a person on bail if he is ready to give self-bond or surety bond as directed by the police or the magistrate. If the accused is unable to furnish bail as directed by the police or the magistrate, then he will be kept in detention until he is able to furnish bail. Now, let's see how bail is obtained in non-bailable offences. Non-bailable offences are serious offences like murder, rape, kidnapping, causing grievous injury, dowry death, etc. If a person is accused of a non-bailable offence, then he cannot get bail as a matter of right. It is the discretion of the police or the magistrate whether to send him on bail or not. For the purpose of granting bail, non-bailable offences are further categorized under two heads. Non-bailable offences where the punishment is death or imprisonment for life, or non-bailable offences where the punishment is not death or imprisonment for life. The police officer in charge of the police station can grant bail to an accused person in non-bailable offences only in the second category, where the punishment is not death or imprisonment for life. In those cases where the punishment is death or imprisonment for life, then it is only the Sessions Court or the High Court can grant bail to the accused person. The court consider following factors while arriving at a decision whether to grant bail to the accused person in non-bailable offences. They are, first of all, nature and seriousness of the offence committed, severity of the offence, nature of police investigation, nature of the evidence collected, character and behavior of the accused person, chances of accused absconding and not available during the time of trial, possibility of the accused person repeating such crime, chances of accused tampering with evidence or influencing the witness in the case, or whether the accused person is a habitual offender. Also, the larger interest of the public and the state whether to release this accused person or not. When the court decides to grant bail to the accused person, that bail is not unconditional. The court imposes conditions while releasing the person on bail. Some of the conditions are that accused person shall not leave India without previous permission of the court. The accused person shall not induce, threat or promise the witnesses in the case. He shall not tamper with evidence. He shall appear and make himself available to the court during the time of trial of his case. If the accused person violates any of the bail conditions, then his bail can be cancelled. In a case where the accused person has committed multiple offences, some of them are bailable offences and some of them are non-bailable offences, in that case, offences are altogether treated as non-bailable offences and bail is not a matter of right, but it becomes a discretion of the court, and the procedure of bail in non-bailable offences will apply in such cases. Thank you.
Thank you so much for watching our video. Stay tuned for our next video.